Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont versus Robert Dyer, case number 24 AP002. Representing the appellant, Robert Dyer, is Sarah Starr, and representing the appellee, the State of Vermont, is Evan Meenan.
Thanks very much. Good morning, counsel. We'll hear from appellant first. Please, counsel, introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. Good morning. I'm Sarah Starr, and I represent the appellant, Robert Dyer.
Thank you.
Mr. Dyer is a senior citizen and a retired baseball and basketball coach with no criminal history. Lives and is the sole caregiver for his 92-year-old mother. Mr. Dyer was charged with 2 counts of misdemeanor simple assault arising from an altercation with another senior citizen at his local service garage. Now, when properly instructed on self-defense, which was Mr. Dyer's only defense, the jury acquitted Mr. Dyer on count 1. This was because Mr. Dyer was clearly defending himself when the first aggressor grabbed him by the lapels to physically throw him out of the garage. Mr. Dyer didn't have any friends or associates with him to come to his defense. He had to defend himself. Mr. Goulet, on the other hand, summoned his close friend and associate to come and help him fight Mr. Dyer. So Mr. Dyer continued to defend himself. There was no break in the action in the first aggression. And then you had Mr. Goulet's decision to call out for assistance from his associate. The friend then came running at Mr. Dyer's blind side, and sensing the approach, Mr. Dyer fully admitted that he swung and tried to hit him in self-defense. So the record here shows that the reason that the court didn't instruct on self-defense was because the court stated there was no connection. And that I read to mean that because Mr. Dyers didn't perceive that his fist made contact with Mr. Humphrey, that there could be no self-defense instruction. And that was clearly erroneous. Certainly there was a connection between the 2 assaults because this was the same affray. And so the connection was referring to whether the punch actually landed. So I think that was the clear error here in terms of not instructing on self-defense when it's the same altercation and there's a clear admission that there was at least an attempt to punch. So if there's no question.
In the charging component of the case, charging or not charging self-defense, what would be the standard of review for that?
I think abuse of discretion, but I mean, in this case, I mean, this was it was clear. I mean, it was an abuse of discretion because this was his only defense. I mean, he admitted taking the swing. And so it was completely prejudicial because he had, once the court decided not to instruct, he had no defense. And so it was, I mean, it wasn't, the jury really had no choice at that point because he admitted that he swung at Mr. Humphrey. And it's well settled that if one sees another person coming towards him in a hostile manner and under circumstances that would lead one to believe he's in danger, he may be justified in using force to defend himself. And that's exactly what happened here. In conclusion, I would ask, well, and then also he has appealed his sentence, which was also an abuse of discretion because this is a man with no criminal record, and he was sentenced to jail for the acquitted conduct. So I think I see the warning. I will reserve the rest of my time. If there's no
Okay.
questions.
All right. I don't see any hands, so thank you. We'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont, which in this case is asking this court to affirm appellant's conviction and sentence for simple assault against Durward Humphrey and unlawful trespass at Craig Goulet's Brighton garage. It's the state's position that the trial court did not abuse its discretion in instructing the jury about self-defense, and that the appellant has not met his burden of demonstrating otherwise. In order to be entitled to a self-defense instruction, the defendant first has to make out a prima facie case for the defense, which means that here the appellant had to show that he was not the aggressor. He used a reasonable amount of force against Mr. Humphrey. He did so based on his honest belief that doing so was necessary to protect himself from immediate bodily harm, and that his belief was necessary. The court concluded in this case that the appellant did not meet his burden of establishing that prima facie case because a, quote, vague, end quote, sense of seeing somebody coming at him from the front of the building wasn't sufficient to conclude that he used only the amount of force that was reasonably necessary to repel Mr. Humphrey's threat. And that decision was appropriate because it was supported by the facts in this case. Specifically, the facts do not establish that appellant had a subjective or honest and reasonable belief that he needed to protect himself against imminent bodily harm from Mr. Humphrey, or that he used a reasonable amount of force to do so. The facts at trial establish that Mr. Humphrey, there was two verbs that were used. I believe one was rolled and one was pulled. But in either event, he either rolled or pulled the appellant off of Mr. Goulet as appellant, and the verb was hitting on Mr. Goulet on the floor. That did not, in the state's opinion, give appellant the right to punch Mr. Humphrey and continue to swing at Mr. Humphrey, especially when Mr. Humphrey was backing away from the appellant. Furthermore, the appellant denied ever hitting Mr. Humphrey. He simply claimed that he tried to hit him because he, quote, sensed someone coming at me. And then the appellant speculated that that person might be coming to Goulet's aid. That's an important fact because one of the limitations on the self-defense is that when a defendant denies using the force alleged in the charge, the defendant is not alleged to a self-defense instruction. In addition, in this particular case, the appellant never specifically testified that he felt threatened by Mr. Humphrey. He merely testified that he sensed someone approaching from his blind side. And it's the state's position that based on those facts, this case is similar, albeit not identical, to the Albarelli case, which is a case that took place on Church Street in Burlington, Vermont. Specifically, the defendant in that case and his friends were verbally yelling and threatening an older man on Church Street. The victim or complainant and his friends suggested to the defendant that he leave the old man alone, and the defendant responded by attacking the complainant's brother. The complainant attempted to stop the attack, and the defendant responded by punching the complainant. And in that case, this court affirmed the decision not to provide a self-defense instruction. The same rationale applies in this case, where the facts establish the appellant assaulted Mr. Humphrey, who was trying to stop a fight, not assault the appellant. But Mr. Humphrey did not threaten or strike the appellant. And
you have 1 minute, counsel. 1 minute.
Thank you very much. And the final fact that I wanted to point out on this topic was that the appellant claimed he assaulted Mr. Humphrey merely because he sensed someone approaching. It's the state's position that while you can assert self-defense to an attempted assault, in other words, you don't need to wait to be physically assaulted before you can defend yourself, the doctrine of self-defense does not recognize the kind of preemptive strike that the appellant used against Mr. Humphrey in this particular case. And absent any additional questions, I imagine I'm fairly close to being out of time. Thank you.
All right. Okay, thank you very much. How much time does the appellant have, please?
Appellant has 52 seconds remaining.
Counsel.
Thank you. It wasn't simply that he sensed Mr. Humphrey approaching. It was that he was defending himself, and then he heard the person that he was defending himself against call out for assistance. He heard the assistance coming. There was simply no evidence to suggest that Mr. Dyer knew or even should have known that this associate was coming to break up a fight rather than coming to help Mr. Goulet assault him. So he established that he had the belief that he was in danger, and he acted to defend himself.
So anything before you run out of time on the sentencing that was imposed? It's 6 to 12 months, all suspended except for 2 days to serve.
Right. It's the 2 days that Mr. Dyer objects to because he has a heart condition, he cares for his 92-year-old mother, and I wouldn't say that it rose to the level of being vindictive, but it was certainly out of proportion and based on acquitted conduct. So that is all I have.
Okay. Thank you very much. Your time is